Thank you, Austis. Good afternoon, everyone. I hope you had a coffee after your lunch and you're not comfortably sitting and trying to fall asleep. So I hope that this presentation you will enjoy. Welcome to those who are present in this building and to those who are online. I don't know if you can hear me. It's not working.
So it's on.
Yeah. Can you hear me?
No, because the mic has retreated.
Okay.
I didn't know that being a host also meant to be a technological wizard, but...
And somebody who pulls people's ears.
Yeah.
Occasionally.
Okay, is it okay?
Yes.
Can you hear her in the back?
Yeah, perfect. So I was thanking you all for being here in the Efta house. It's actually the house of the EEA agreement. That's where all the work in relation to the EEA agreement for Norway, Iceland, and Liechtenstein happens. It's not in Geneva, it's in Brussels, and it's in this building. And thanks to all the colleagues from the European Commission who are joining us online. I hear that there's a lot of the coordinators from the Directorate General who are in contact with Nicolas von Lingen and his team in the Secretariat General who are following today. So today's presentation is also addressed to you, and I'm looking forward to any questions that would be coming in later on, and maybe ahead of a visit that you would want to pay us in this building. So you remember that family picture that we saw earlier on of the 25 years of the EEA agreement? Well, on that occasion, Donald Tusk, the European Council President, referred to the EEA agreement as something that is not a short-term transaction, but a long-term partnership where everyone contributes and everyone benefits. So the institutional structure we're going to be speaking about today, you've heard about the Efta Secretariat and how EU law becomes EEA law. What we're going to be looking at this afternoon is how EEA law is being applied, implemented, and enforced, and the role of the institutions that have been put in place in the Efta pillar for that purpose. I come from the Efta Surveillance Authority, which is a bit like the Commission with regard to monitoring compliance with the EEA agreement. And there is obviously the Fta Court, which is a bit like the Court of Justice of the European Union when it comes to the judicial control of what happens with regard to the law. Since our colleagues from the court were not able to join us today, I'll try to cover a little bit of that and give you a flavor of how the Fta Court looks and what they do. So we will be talking about the implementation and how the agreement is enforced. You've heard enough this morning about what the EEA is. Here is also a version on the map. It's 30 countries, it's the 4 freedoms, it's a flanking policies environment, which is very visible at the moment because of the challenges that our planet and our continent face. And it's an internal market for 450 million people, out of which the EEA part is approximately 5.5 million people. So the role of the Efta Surveillance Authority is to monitor the compliance with EEA law in the 3 states, in Iceland, Liechtenstein, and Norway. This means that Essa is not there to apply EEA law on its own. It's the states that have the responsibility to incorporate that legislation into their national law and to effectively apply it. And what we do is to make sure that this happens, and when it doesn't, to engage in a dialogue with the states to make sure that we reach that result. So the law that we ensure compliance with has 2 sources, the EEA agreement and the Surveillance and Court agreement. The EEA agreement is where all these acts are incorporated every time there is a joint committee decision. And it's an agreement which has the EU and its member states on the one hand, on the one side, and the 3 EEA Efta states on the other side. So it's the agreement that covers the whole area of the EEA. The Surveillance and Court agreement is an agreement that is only in the Efta pillar. So it's an agreement between Norway, Iceland, and Liechtenstein, which relates to the institutions and the powers of the Efta Surveillance Authority and how we do things within the pillar to attain the objectives of the EEA agreement. So the EU side does not have any involvement when it comes to the application of the surveillance and court agreement. You've seen this slide before today. So you will see on the left, the third box from the top, the Efta Surveillance Authority, and under that, the Fta Court. And you see that they mirror the European Commission and the Court of Justice of the European Union. And also that the noteworthy thing is that there is no common institution that brings them together. This means that the monitoring of the implementation of the agreement is a self-policing matter in the Efta pillar. It means that the Efta Surveillance Authority and the court have the ultimate responsibility for that monitoring of compliance. The EU doesn't get involved in that monitoring of compliance directly. So it is a great matter of trust. The good functioning of the agreement relies on this trust from the Efta side that the EU is properly monitoring the implementation of the EEA rules on the EU side, and trust from the EU towards our institutions that we are properly monitoring the implementation of the EEA agreement on the Efta side. For our colleagues from the Commission, and maybe it's a bit of more of general interest as well, I wanted to have some details about what brings Essa and the EU Commission so close. So the Commission is known as the guardian of the treaties, making sure that primary law, the law that is written in the treaties, is applied throughout the EU. Essa has a corresponding role with regard to the EEA agreement. So we are checking that the states respect the rules that are in the EEA agreement. There is, of course, an enormous difference between the Commission and Essa. The Commission has the role to initiate legislation, new legislation in the EU, and as Essa, we don't have that power of legislative initiative. As you heard this morning, all the work of incorporating things into the EEA agreement are within the responsibility of the states, and they are supported by the Efta Secretariat. So both the Commission and Essa, we investigate breaches of EU. Importantly, we have state aid and competition rules on each side, both in the EU and in the Efta pillar. So in that regard, also Essa has similar powers to the Commission when it comes to state aid and competition rules. The other interesting thing to know is that the internal structure of Essa, by the way, Essa is tiny. It's a boutique institution compared to the Commission with its 32,000 staff members. Essa, I think we are 70 people with a fixed term contract. So the proportions have to be kept when we say this. But in Essa, we also have directorates who are responsible, like the Directorate General of the Commission, for specific sectors. We have a competition and state aid directorate, and we have an internal market directorate who deal with the substance of these rules. Then we have the administration, which supports the organization when it comes to staff and other organizational matters. And we have my department, the Legal and Executive Affairs Department, which provides legal advice, a little bit like the legal service of the Commission, does the litigation, and also provides the day-to-day executive support for college decision-making, like the General Secretariat of the Commission. So this, the fact that there are these structures that are closed, they certainly facilitates the understanding between institutions. And that's very important because what the EEA agreement says is that the Commission and Essa cooperate, exchange information, and consult each other on surveillance policy and individual cases. This means that when choices have to be made as to which way to go in a certain area, whether it's important to, I don't know, look at the specifications of tunnels and whether they are safe throughout the EEA. If the Commission is doing that, our colleagues in the Internal Market Directorate get to hear that and are able to liaise with the Commission to be doing the same thing at the same time on the Efta side if the conditions are there. So the fact that work is carried out sometimes in parallel also helps to spot problems that could be similar in some of the Efta countries and some of the EU countries, and to try to address them in a common way across the pillars, even though the responsibility remains with each of the institutions. You will also find it interesting to know that on a lot of the very technical pieces of legislation, like food safety, which are a big part of the legislation that's incorporated in the EEA agreement every year, it is very important to carry out inspections, and for those inspections our colleagues from the Commission work very closely with our colleagues in Essa and participate in each other's inspections to build this common knowledge and common approach to enforcement. Apart from the Commission, Essa cooperates also with many EU agencies. I won't go into the details, but you will. I wanted to have this little list here for you to have a look at and read more on it if you're interested. And here is the decision-making body, the College of Essa. They're responsible for adopting the decisions and for setting out the priorities for the organization. In the middle, you have Arne Roksund, our president from Norway. On the right-hand side, Stefan, who's also in the room, Stefan Bariga, who's nominated from Liechtenstein, and Arni Pal Ardason from Iceland. So our college members do not represent their countries. That's a very important point. They're independent from their countries. They bring, of course, the knowledge of the legal system and of the political sensitivities with them, which are essential in decoding what is going on and how to better address certain issues. But they are completely independent and do not take instructions from the governments and from the states. And that goes, of course, throughout the organization as well. The same is true for our staff members. So what are the obligations of Norway, Iceland, and Liechtenstein that we check? We first check that all the acts that are incorporated into the EEA agreement, every time the EEA agreement grows and gets new rules, that these new rules are transposed in the states, so that they are turned into national legislation giving effect to the EEA law obligations. But it's not enough to take those rules and put them in national law. It's important to do it correctly, and so that the law matches the EEA agreement. And it's not enough that it's correct on the books, it also has to be correct in practice. So throughout our monitoring processes, we check these three things. Obviously, whether there has been a law passed in Parliament to transpose something is a tick-boxing exercise more than anything else, and it gets more complicated the moment you look into the quality of what's in the law and how it is applied in practice. So this graph shows the first step of what I described. How many, this is relating to directives only, how many directives are being late for incorporation into national law. So these are directives that are part of the EEA agreement, for which the states have the obligation to put national legislation in place to give it effect, and the deadlines have passed and they're late, so we are after them, sending them letters reminding them to do so and trying to encourage them to do that. So this is a scoreboard that Essa publishes, I think, twice a year at the moment. This is a practice that the Commission also has, the Internal Market Scoreboard. So it's a practice that has developed in parallel to that of the Commission. And you will see that, yes, some countries are doing better than before at the moment, and others are having more difficulties. So what tools do we have as an organization, as an institution, to get the state to comply? Because our role is obviously not to just point the finger and find the bad students in the class, but rather to try to find ways to accompany the states and encourage them to correctly transpose and apply the rules that are part of the EEA agreement. First is this monitoring. We follow what is going on. Some pieces of legislation have reporting obligations to Essa. For example, when you build a new tunnel, you have to inform Essa of how many emergency exits at what distances you have put in the tunnel that you're constructing. So that's one way we're following developments. The other one is by watching the news or getting in touch with the ministries and asking questions. We are investigating also when there's a specific issue that seems to not be ideally, that doesn't look ideal from a first glance. We go into it, and our colleagues in the internal market directorate contact the ministries and ask questions about the law and the practice. When things don't get right, or when we find out that there has been an infringement, what we do is we launch an infringement proceeding, a bit like what the Commission does, which can end up with the Efta Court. And often the threat of it ending in the Efta Court is sufficient internal pressure in the states to get going and to get things moving to get to compliance. I mentioned inspections earlier in the food and vet sector, in the transport sector. These are inspections to state authorities to check that the ports respect security rules, that the airports have enough security clearances to ensure safety. And we can also carry inspections in the context of competition investigations. In which case we do down raids on companies which we suspect to, for example, abuse their dominant position. The other tool we have is the possibility to impose fines on undertakings when they don't respect the competition rules. And the latest and most known one is the fine that we imposed on Telenor, the Norwegian telecoms operator, for abuse of dominant position. That went to court and survived the court scrutiny, so the fine was confirmed. So how do we come to start infringement proceedings? We get to hear about possible infringements if someone files a complaint. Anyone in the EEA can complain that if their rights have been infringed upon, if they have not been respected by the states, by the 3 states. Of course, if they complain about an EU member state, they will need to file that complaint with the EU. But if it's a complaint against one of the 3 states, then this would come to us. And we also have the power to open, out of our own initiative, cases where we have a suspicion that the law is not being applied properly. And this is not a closed system. It's not 2 avenues that have to be decided early on. If a complaint comes in, we can decide to either treat it as a complaint, as a response to the complaint, or we can choose to move beyond the complaint and open also an own initiative case to look at the subject in a wider manner. So what happens in an infringement is that if we have found, after an initial checking things and looking for information, we think there is indeed an infringement of the law, and that's either because the state has not transposed the legislation in national law, or has transposed it wrongly, or does not apply the correctly transposed law, does not apply it correctly. So what we do is, the first step is to send a letter of formal notice. Again, this is a procedure that is the same on the EU side. And then the state gets a chance to explain itself in writing about whether it thinks we misunderstood something, or why they think they are in compliance. If things have not moved and we still think that there is a breach, then we move to the next stage, which is the reasoned opinion. And it's a very important stage because it's the last, let's say, step before the court. And we need to have set out all the legal arguments that we would eventually need to use in front of the court if we were to go down that route. So again, after a reasoned opinion, the state has a chance to respond and bring either legal arguments or evidence that we were wrong in our assessment. And if the issue is still not resolved, then we have the option to bring the case to the Efta Court to get a declaration of non-compliance. So in the end, when Essa takes action, we take, of course, a responsibility for a certain interpretation of the EEA agreement, but the legal question of whether there was a breach or not is for the Efta Court to say in legal terms. And like the Commission, we have discretion on how to use this procedure. We have to follow the steps if we do, but at any stage, if we think that the situation has been sufficiently addressed, we can also close the case at any stage. So here you see the total number of infringement cases. So these are not cases that are at the court at the moment. These are cases that are being followed up by our colleagues in the Internal Market Directorate. And at the moment there are 188 cases of infringements. Some of them will be what we call non-in-regs, non-incorporation of legislation. So it's the first of the three checks, the check whether the legislation has been incorporated. So it's the tick boxing exercise, and we checked the box and it hasn't been ticked yet. So many of those cases are simply there is no national legislation in place at the moment. Others are what we call substance cases, so cases where the legislation is in place or is not in place, but is not satisfactory. So I talked a lot about the infringements, but a big part of what we do in Essa is also competition and state aid. And there it's a bit of a different environment compared to the enforcement of the four freedoms as I described it before. In the same way as in the EU, state aid is prohibited under the EEA agreement unless it falls under certain exceptions. So the substantive rules are the same as in the EU, and like in the EU, Essa has the power to monitor, has the responsibility to monitor the aid given by the states. And the reason is to make sure that there is a level playing field and no state supports certain businesses more than others. Or discriminates and distorts competition in the internal market. So we have a monitoring role, and any new aid that is decided needs to be approved by Essa. This was very much used during the pandemic for the support schemes to deal with COVID, and in I think in 2021 there were 32 decisions assessing the aid given by our states in the context of the COVID pandemic. I talked a bit about competition earlier, the power to do down rates and check on undertakings to make sure that they don't have anti-competitive practices that distort competition in the EEA. It is fundamental in the level playing field with the EU, and we are the guardians of that, and our colleagues in the Competition and State Aid Department work very closely not only with the European Commission, but also with the national competition authorities in our states to exchange information and support each other in the investigations. Essa also has the power to that was probably about state aid, so that's something I should have mentioned earlier. But in the context of state aid, Essa has the power to request the reimbursement of aid that has been unlawfully paid. And in competition, Essa has the power to impose fines. I referred to the Telenor example earlier on. So I'm going to speak a little bit about the Efta Court. The Efta Court has kind of similar role to the European Commission, to the European Court in Luxembourg. They're also based in Luxembourg. and they hear cases that are either brought by Essa against Norway or against Iceland or against Liechtenstein for a breach of EEA law, or they hear challenges to Essa's decisions. For example, the Telenor fine that Essa imposed, that was challenged before the Efta Court, and it was the Efta Court that declared that it was validly adopted and that Essa was right in imposing that fine. So these are the direct actions. And the Efta Court also has a very important role to be in dialogue with the national courts, because the day-to-day judge of EEA law, like in the EU, are the regular judges who get to apply the national legislation that comes from the EEA agreement. So in the same way that EEA law affects the lives of everyone, free movement of persons, access to healthcare, insurance reimbursements, all of these matters are regulated by EEA law, and they're part of the national legal systems through this incorporation. So the reality of EEA law is that it is basically enforced by the national judges most of the time. So when a national judge is confronted with a question of interpretation of EEA law, it can send a question to the Efta Court as to how to interpret it. And the value of that is to give an interpretation that is relevant also for other judges in that state, but also across the EEA, even in the EU. So we call these advisory opinions that the court delivers in this process of dialogue with the national judges. And it looks very much like the preliminary ruling references in the EU pillar with the European Court of Justice. So these are the three judges that we have at the moment. They're appointed, they're nominated by their state and appointed by the three states together. And we also have a list of ad hoc judges in case of conflicts of interest on a particular case. So I spoke a little bit about the Efta Court and the direct actions. The two types of direct actions, either Essa being taking the action to the Efta Court against the state, or any person who thinks thatEssa's decision is wrong and has standing, a direct action against Essa at the Efta Court, and the advisory opinions. We are not only active at the Efta Court, Essa also deals with other courts. The EU's Court of Justice, primarily, we are intervening in quite a number of cases, especially in competition, and to support the Commission decisions. So we have very few cases in the competition area, but our expertise is also being built through this continuous dialogue with the Commission on competition law. So we follow developments closely and try to contribute to the evolution of the law before the EU courts. So that's a very interesting feature of the EU and Efta pillars, that it is possible both for the Commission to be present at the Efta Court and support a certain interpretation of EEA law that comes from EU law, and at the same time Essa can be present at the EU courts to give its views on how to interpret EEA law when it is being examined by the EU courts. And we have had instances where legal questions that arise between Norway and Essa have also arisen in the EU, in another member state. And so you find Essa and Norway defending their views and their vision of how the rules should be interpreted in front of the EU courts, who get to answer the question first. We also have the possibility to intervene before national courts, the legal system, because that's what the legal systems of Norway and Iceland in particular allow, and we use that very sparsely, but it is a possibility. And Essa has also intervened in front of the European Court of Human Rights the European Court of Human Rights in the last years have been given some attention to the nature of EEA law, looking at the similarities between EU and EEA law and trying to see if the presumption that EU law conforms with fundamental rights should also be transposed as such for EEA law. So that's a question that remains open at the moment and might be coming back in Strasbourg at the European Court of Human Rights. And with that, I end the presentation and look forward to your questions later on.